In a rather startling turn of events, the Commonwealth Utilities Corporation, named as a defendant in a taxpayer lawsuit, sides with the plaintiffs on a controversial power deal. On December 25th, CUC, through legal counsel Deborah Fisher, filed an opposition to fellow defendant Saipan Development's motion to vacate an injunction imposed on the company's 25-year, $190 million power purchase agreement. The PPA was signed in August by Governor Fitzgerald and former Attorney General Ed Buckingham, and enjoined days later in a taxpayer lawsuit filed by about a dozen lawmakers. Through attorney Bill Fitzgerald, Saipan Development argues that the injunction is neither necessary nor legally valid. Fitzgerald says the plaintiffs, represented by attorney Ray Kitutu, have presented no evidence to support their claims that the PPA is a bad deal for the CNMI. From an interview last month, Fitzgerald.
Where is the evidence that this is a bad deal for the CNMI? Where's the affidavit by a power expert that says that this is an unconscionable deal, it's too expensive, and it will cost the CNMI more money than if they didn't get a new power plant? They presented no evidence to that. So if they presented no evidence, they shouldn't have been allowed to get an injunction.
But in a surprise move, CUC has stepped forward with evidence and affidavits advising against the deal. CUC says without the injunction, the utility would be forced to immediately raise electric base rates by a whopping 88% in 1 year, just to cover upfront costs associated with the PPA. At least $18 million will be needed to fund the decommissioning of the old power plant, the construction of a new substation, and the development of escrow and contingency funds. Sworn statements by CUC's Chief Financial Officer Charles Warren and Deputy Director for Power Wallen Fong attesting to these claims are included in the court filings. CUC also says the plaintiffs are likely to prevail on the merits because the PPA is illegal. According to CUC, the contract violates procurement rules in part because it wasn't signed by the Executive Director or the CFO. Although the utility was under a state of disaster emergency at the time, CUC notes that the Governor's declaration suspended only regulations of the Public Utilities Commission and not CUC. The corporation also says CNMI law does not allow for the sole sourcing of power plants, and under Public Law 1734, no power plant contract may be awarded to a contractor who has not operated a major source of emission in compliance with federal environmental standards for at least the past 5 years. Saipan Development was formed just 5 days before receiving a sole source power plant design and management contract in March this year. According to CUC, the government is not bound by unauthorized acts of its officers or agents, and the contract was void from the very beginning. And just a quick correction, today is actually December 26th. Meanwhile, in a statement, the plaintiff's attorney, Ray Kitutu, says his clients are pleased that CUC opposes Saipan Development's motion to vacate the injunction. He adds, quote, "CUC is correct that plaintiffs are likely to prevail on the merits as the PPA is illegal on its face," end quote. The plaintiff's opposition on this matter is due on December 27th. We were not able to reach Saipan Development for comment.